Welcome to my series of lectures and discussions on the law, or the lex in Latin, if you prefer. I am not limiting where we may go. Law in history, law in philosophy, law in society, legal systems of the world, past, present, and future. Most of all, we will look at law in practice and how it is lived and experienced by those caught up in it. Here are some of the themes we will touch on or explore going forward. As you can see, I am not particularly ambitious. I have been practicing law for 28 years, so this is a journey back for me. Back to one of the first books I ever read on the law. Title, The Idea of Law, by Dennis Lloyd. An old book, but a good place to start. Baron Lloyd of Hampstead was a British jurist and was created a life peer in 1965. He was head of the Department of Laws at the University of London from 1969 to 1981. The book was first published in 1964, which puts it at what I would argue is one of those great divides in civilization and in our idea of law. When you consider the clashes between law and morality, when it was written, 1964, the death penalty, abortion, divorce, civil rights, and the clashes that are shattering the world today, you can see the book was written when the forces of radical egalitarianism that had sputtered, risen and fallen since the French Revolution in 1789 were about to be unleashed in all their fury on the world. Today, these forces, one could argue, are reaching a storm pitch. What I want to focus on today is the first chapter of Lloyd's book, titled, Is Law Necessary?, which will introduce many of the key players and ideas that we need to understand going forward. Law is perhaps the only institution central to the moral, social, and even the spiritual nature of man that few even get a chance to study in modern society. Why is that? It's as if someone likes keeping law mysterious, distant. In our wonderful society, law remains remarkably exclusive, as if those who are intent on using the law to change the world to their liking would prefer to keep it mysterious and distant to the subject population. Yet, perhaps more so than ever, today people turn to the law to make the world more just, while others look to the law to protect them from oppression. People see law as capable of doing both those things, achieving these lofty goals on its own, really. Why? No matter what camp you're in, you expect to preserve or transform the world with laws. But people who imagine they are protected by grand proclamations of their human rights, or that by making laws they will change humanity, are often disappointed. Why? That will be one of the questions we will look at. The cover of my worn copy of Lloyd's book has the subtitle, Law, a Repressive Evil or Social Necessity. Well, if society in its perfect form is the union of order and chaos, perhaps we will find that law too is the union of oppressive evil and social good. We will see. Which brings us to another theme. Can any law function or do what it is intended to do in an evil society or an immoral society, by whatever standard you understand those terms? Now to Lloyd's Chapter 1, Is Law Necessary? It may seem strange that at the very outset of our inquiry into the idea of law, the question should be raised whether law is really necessary at all. In fact, however, this is a question of primary significance, which we ought not, and indeed cannot, take for granted, for it arises out of an uneasy and perplexing doubt, not only whether law may be expendable, as being unnecessary to the creation of a just society, but also whether law may not perhaps be something positively evil in itself, and therefore a dangerous impediment to the fulfillment of man's social nature. Fantastic though this viewpoint may seem to the members of a well-ordered democratic society, whatever its particular shortcomings or imperfections may be, It is useful to remember that in many less well-regulated societies, the operation of law may appear in a more unfavorable guise. Moreover, the feeling that law inherently is or should be necessary for man in a properly ordered society receives little encouragement from the long succession of leading Western philosophers, from Plato to Karl Marx, who, in one way or another, have lent their support to the rejection of law. Hostility towards law has also played an important part in many of the great religious systems of East and West, and was a crucial element in the ideology of the Christian Church in its formative period. And apart from Marxists, there are still to be found other serious supporters of a doctrine of anarchism as an answer to man's besetting personal and social problems. Every age, and certainly our own, is no exception, produces individuals or groups who feel a general restlessness against all authority, and who respond to this feeling by giving vent to various acts or demonstrations against the forces of law and order. No doubt such people are often sincerely motivated by the vague notion that in some mysterious way their demonstrations will lead to a better and happier life for mankind. But such sporadic outbursts have generally had little influence on the main currents of human thought and feeling. We must therefore look deeper than the external manifestations of social restiveness in trying to explore the ideological foundations of dissatisfaction with the very idea of law, in order to find out what it is that has urged so many in civilizations geographically and culturally so far apart, and throughout human history, either to reject law altogether or to regard it, at best, as a necessary evil suited only to an utterly imperfect state of human society. When we talk of some idea or concept as being ideological in character, we mean that it forms part of our outlook upon the world, upon the relation of man to the world and to society in all its manifestations. The idea of law certainly partakes of this ideological character, so that our view of it will inevitably be colored by our general thinking about man's place in the world, the view we may adopt of the nature of man, or of the human condition, in quotes, as some modern writers prefer to call it, and the aims or purposes which man may be called upon or required to fulfill. When we assert that law either is or is not necessary to man, we are clearly not trying to state a simple physical fact, such as that man cannot live without food or drink. We are engaged in a process of evaluation. What we are really saying is that man's nature is such that he can only attain a truly human condition given the existence or non-existence of law. Such a statement contains implicit within it an assumption as to man's goal or purposes, as to what is good for man, and what he needs for the attainment of those objectives. It is no doubt because of man's perennial and intense preoccupation with such issues that thinkers of all ages and societies have been drawn into the interminable dispute as to the ethical quality or potentiality of man's nature. This dispute may indeed be thought by many today to be not only interminable, but also senseless. But whether this is so or not, the position taken up has formed the major premise in leading to the deduction whether, or to what extent, law is necessary for man, and so its importance for this purpose remains undeniable. For those who see in man either the incarnation of evil, or at best an amalgam of good and bad impulses constantly in conflict, the bad tending repeatedly to prevail over the good, it seems evident that here are dark and dangerous forces implanted in man's very nature, which need to be sternly curbed, and which, if not curbed, will lead to the total destruction of that social order in whose absence man's state would be no higher than that of the animals. Law, then, in this view, is the indispensable restraint upon the forces of evil, and anarchy, or the absence of law, the supreme horror to be warded off. On the other hand, those who view man's nature as inherently good seek to find the sources of the ills of man's present condition in situations external to man himself, and hence look for some fundamental defect in man's social environment as the true cause of the evils which afflict him. And as the most conspicuous features of this environment are, of course, the government of the reigning powers and the legal system through which they exert their political authority, it is hardly surprising that criticisms center upon these as the true source of human tribulations. In an age of social reform such as the last 100 years in the West, it might seem that such critics would have better directed their shafts to the reform of the existing law rather than to its total elimination. But on the other hand, it must be borne in mind that in many societies the evils of the legal regime must have seemed to the religious or philosophically minded to be inescapable, and that to replace one regime based on legal repression by another could only result in a comparable series of afflictions and oppressions. The only course, therefore, was to condemn legal restraint, root and branch. Two very different starting points were taken by those who looked upon law as a means of attaining social harmony by the curbing of evil passions of man. On the one hand, some postulated that man's nature was intrinsically evil, and that no social progress could be attained without the restraints of penal laws. On the other hand, were those who held that man was originally created good by nature, but that due to sin, corruption, and some other internal weakness, such as avarice, man's original and true nature had become distorted, and thus required for its control the rigors of a punitive system of laws. Those who favored the more optimistic assessment of human failings tended to look backwards to an earlier golden age of primeval innocence, when men lived simple, happy, and well-ordered lives without the need for any external system of legal rules or coercion, to restrain their impulses, which were wholly unselfish and directed to the common good of mankind. Such was the idyllic primitive scene as depicted by many writers from Seneca to Rousseau, and even in our own day, and this roseate view of man's remote past has often served as a pattern for a movement towards a return to nature, in the sense of man's primitive, unspoiled nature, in which uncorrupted natural impulse will replace a coercive regime of law. Examples of both these ideological views of man's nature and destiny can be drawn from very widely scattered sources. Only a few need to be mentioned here. In ancient China of the 3rd century BC, we find, for instance, the important school of the so-called legists, who argued that man's nature was initially evil, and that the good ways in which men often acted were due to the influence of the social environment, particularly the teaching of rituals and the restraints of penal laws. A single law, enforced by severe penalties, is worth more for the maintenance of order than all the words of all the sages, was one of their governing maxims. About the same period, the Shastra writers in India were asserting that men are by nature passionate and covetous, and that if it were left to themselves, the world would resemble a devil's workshop, where the logic of the fish would reign. That is, the big ones would eat up all the little ones. Comparable views are not difficult to locate among some of the seminal writers of modern Western Europe. Thus, for Bodin, who's a French political writer, the original state of man was one of disorder, force, and violence. And Hobbes' description of the life of primitive man as a state of perpetual warfare where individual existence was brutish, nasty, and short has become classical. For Hume, too, without law, government, and coercion, human society could not exist, and so in this sense law was a natural necessity for man. Machiavelli based his celebrated advice to princes to disregard their pledges when these conflicted with their own interests on the argument that men, in quotes, are naturally bad and will not observe their faith towards you, so you must, in the same way, not observe yours to them. The hypothesis of a primitive golden age has in one form or another always played an important part in the history of Western ideology. Two of the best-known statements of this hypothesis in classical antiquity are to be found in the pages of Ovid and of Seneca. Ovid, in the first book of the Metamorphoses, refers to it in these terms: "The golden age was first, when man yet knew no rule but uncorrupted reason knew, and with a native bent did good pursue, unforced by punishment, unawed by fear. His words were simple and his soul sincere. Needless was written law, where none oppressed. The law of man was written in his breast. No suppliant crowds before the judge appeared, no court erected yet, nor cause was heard, but all was safe, for conscience was their guard." Seneca's celebrated account, as befitted a philosopher, was more circumstantial. "In this primitive state, men lived together in peace and happiness, having all things in common. There was no private property. We may infer that there could have been no slavery, and there was no coercive government. Order there was of the best kind, for men followed nature without fail, and the best and wisest men were their rulers. They guided and directed men for their good, and were gladly obeyed, as they commanded wisely and justly. As time passed, the primitive innocence disappeared. Men became avaricious and dissatisfied with the common enjoyment of the good things of the world, and desired to hold them in their private possession. Avarice rent the first happy society asunder, and the kinship of the wise gave place to tyranny, so that men had to create laws which should control their rulers." Although Seneca asserts that this primitive innocence was rather the result of ignorance than of virtue, he attributes the latter social evils and the necessity for the introduction of a regime of law to the corruption of human nature from its initial state of innocence. And this corruption he explains as due specifically to the development of the vice of avarice. This idea of vice and corruption as the reason for the establishment of coercive institutions became a key feature of Western thought for many centuries, adapted as it was by the early church fathers to the Judeo-Christian version of the fall of man. The biblical account of paradise was equated with Seneca's primitive state of innocence and the necessity for human law and all its familiar institutions, such as the coercive state, private property, and slavery, was derived from man's sinful nature, which resulted from the fall. Law was a natural necessity after the fall to mitigate the evil effects of sin. Even the family was treated as a consequence of the fall, for it represented the coercive domination of the male as against the freedom and equality of the primitive paradise. Slavery, too, was regarded as one of the inevitable consequences of the fall, for man, though in his uncorrupt state free and equal, as a result of sin, was made a fit subject for enslavement, and thus, in a corrupt age, slavery was a legitimate institution. This theory of law and government attained its classic restatement in the writings of Augustine. State law and coercion were not in themselves sinful, but were part of the divine order as a means of restraining human vices due to sin. Hence, all the established legal institutions and the state powers were legitimate, and coercion could properly be used to enforce them. Augustine saw the future hope for mankind not in the sphere of social reform, by promoting a juster social regime on earth, but rather in the attainment of a commonwealth of God's elect, a mystical society which would ultimately, in God's good time, replace the existing regime dominated by man's sinful nature. Augustine wrote at a time when the great system of the Roman Empire was on the point of disintegration. There seemed but little prospect of a rise of an orderly, let alone a just society, by mere human dispensation. But gradually, life became more settled and provided scope for social and economic advancement. Moreover, by the 13th century, some of the more scientific and philosophic reflections of classical antiquity upon man's social condition, especially those of Aristotle, had filtered through to Western Europe. The time was ripe for a change of emphasis. Man's nature might be corrupt and sinful, but he still possessed a natural virtue which was capable of development. Leaning heavily upon Aristotle's conception of the natural development of the state from man's social impulses, Aquinas held that the state was not a necessary evil, but was a natural foundation in the development of human welfare. Aquinas, as a pillar of orthodoxy of the medieval Catholic Church, strove to reconcile this position with the established theology of his day. Nevertheless, he also provided an important basis for the later secular view of law as at least potentially a beneficent force, not merely for restraining the evil impulses of man, but also for setting him upon the path of social harmony and welfare. In this way, law came to be envisioned not as a purely negative force for the restraint of evil, but as a positive instrument for realizing those goals towards which man's good or social impulses tend to direct him. Now, at this point in the chapter, Lloyd discusses the contrasting view of the anarchist, which is very different from the view of those thinkers who believe law is necessary to restrain man's evil instincts. The anarchist view is entirely different. For such thinkers, and I'm now quoting Lloyd again, for such thinkers, man's nature is and remains basically good. But it is the social environment which is responsible for the evils of man's condition. And above all, the existence of a regime of law imposed by force from above. A mood of wistful primitivism, a nostalgia for a primeval golden age, has colored a good deal of what may be termed anarchist thought, from ancient to modern times. Plato, for instance, showed strong leanings towards primitivism, as is illustrated by his assertion that, in quotes, "the men of early times were better than we are and nearer to the gods," close quotes. Yet this approach tends to be an altogether more sophisticated one, concentrating far less on a mythical past than on man's potentiality in the future for an ideally just society. Moreover, such a society is not to be one with an ideally conceived legal regime. On the contrary, one free from all legal rules in which rational harmony will prevail as a result of the good sense and social impulses of its members. An idealist picture of a state without law, whose inner harmony derives from human reason, carried to its highest potential development by a succession of philosopher kings chosen for their wisdom and knowledge, is presented by Plato in his Republic. Plato pins his faith upon a system of education which will not only produce adequate rulers, but which will also serve to condition the rest of the population to the appropriate state of obedience. Modern experience certainly supports Plato in his belief that education or brainwashing may condition people to subservience, but remains divided on the notion that any system of education can provide a royal road to wisdom, or that there is any foolproof manner of selecting or training persons who are naturally preordained for rulership. It may be said that Plato's leanings were not so much towards anarchism as towards what we should today term totalitarianism, as his proposals for an inflexible and rigorously enforced legal system in his late dialogue, The Laws, sufficiently demonstrate. Again, though there was unquestionably an anarchic flavor about certain aspects of primitive Christianity, this was manifested in a contempt for, rather than a rejection of, human law. And indeed the injunction to render unto Caesar what was Caesar's became accepted as conferring a divine legitimacy on the established powers. At the same time, the cult of nonviolence appeared to many opponents of the early Christians as a threat to state authority, and has afforded a base for the anarchistic doctrines of some influential modern writers, such as Bakunin and Tolstoy. The modern period from the 17th century has been marked by the rise of science and technology, and with this has developed the ideology of human progress, a worldview which rejects the belief in a primitive paradise and looks forward to an ever brighter future for mankind. For long, this doctrine was wedded to the notion that the social evolution of man could be left to the free play of economic forces, which, if not interfered with, could be assumed to work towards ultimate social harmony. This was the theory of laissez-faire, which, though applied by Adam Smith, especially to economic affairs, carried with it the broader doctrine that all government and law were in principle evil, insofar as they constricted or distorted the natural development of the economy and of society. Far from being anarchist, however, this theory strongly favored the use of coercive law for the protection of private property, which it regarded as an indispensable feature of a free market. The 19th century presented perhaps the heyday of the most sophisticated anarchist writers, though Godwin's celebrated contribution, Political Justice, first appeared in 1793. Godwin argued that the evils of society arose not from man's corrupt or sinful nature, but from the detrimental effects of oppressive human institutions. Man is inherently capable of unlimited progress, and only coercive institutions and ignorance stand in the way. Godwin held that voluntary cooperation and education would enable all law to be abolished. Such moral and social norms as were required for maintaining social order and progress would be made effective in that their violation would incur the moral censure of the free individuals of which society would consist. This type of philosophic anarchism was further expounded by the leaders of the Russian school of anarchists, Bakunin and Kropotkin, for whom the state, law, coercion, and private property were the enemies of human happiness and welfare. These writers stressed the beneficent role of cooperation in human history and believed that in the inevitable course of evolution, the principle of mutual aid would replace the miseries of the coercive community. Tolstoy, on the other hand, propounded a form of anarchy based on his conception of the simple Christian God-inspired life, led by the early Christian communities. Many of his enthusiastic supporters attempted to set up Tolstoy colonies on these lines in various parts of the world. But the results were hardly inspiring. In his very sympathetic life of Tolstoy, Elmer Maude relates some of the strange and comic ways in which these societies speedily collapsed. In one such colony, for instance, a boy stole a waistcoat from a fellow colonist. This youth had previously been indoctrinated by his companions in the view that private property is wrongful, and that the police and the law courts are part of an immoral regime of coercion. When the return of the waistcoat was demanded, the youth proved to have learned his lessons only too well. If property is wrong, he inquired, why was it more wrong for a boy to have it than a man? He wanted the waistcoat as much as the man did. He was quite willing to discuss the subject, but he would not alter his opinion that he was going to keep the waistcoat and that it would be very wrong to take it from him. Now, does that sound familiar? Another such colony came to a rather drastic end. The property of the colony was bought in the name of a member who held it for use of his fellow members. One day an eccentric individual appeared on the scene, and after some discussion with the colonists, suddenly rose and made the following announcement. Gentlemen, I have to inform you that from today your colony will have neither house nor land. You are astonished, then I will speak more plainly. Your farmhouse, with its outbuildings, gardens, and fields, now belongs to me. I allow you 3 days to go. The colonists were thunderstruck, but none of them resisted, and they all cleared out of the place. 2 days later, the legal owner presented the property to the local commune. A cynic might well chuckle at this vindication of his disbelief in the natural goodness of man. But the outcome of these naive anarchist exercises undoubtedly points to the fundamental dilemma which must face those who believe that human society can function without the external cement of coercive law. As Maud remarks, remove the law and induce men to believe that no fixed code or seat of judgment should exist, and the only people who will be able to get on at all decently will be those who, like the Russian pre-revolutionary peasantry, follow a traditional way of life. The root of evil of Tolstoyism is that it disdains and condemns the result of the experience gained by our forefathers, who devised a system which, in spite of the many defects that still hamper it, made it possible for men to cooperate practically and to carry on their diverse occupations with a minimum of friction. At this point in the chapter, Lloyd talks about Marx, who he describes as one of the most remarkable of the modern anarchists. He states, Marx envisioned the overthrow of the capitalist society by a violent revolution of the oppressed proletariat. Law was nothing but a coercive system devised to maintain the privileges of the property-owning class. By the revolution, a classless society would be brought into being, and law and the state would wither away, as being no longer needed to support an oppressive regime. The Marxist looks forward rather than backward to a golden age, when social harmony will be attuned to the natural goodness of man, unimpeded by such environmental snares as the institution of private property. Such a social paradise cannot, however, arise overnight, and therefore we have the paradox that during the interim period, likely to be of indefinite duration, there is need for a vast increase of state activity supported by all the apparatus of legal coercion, so abhorrent to the anarchist. Lloyd states, it seems incontestable that the introduction of Marxist socialism has so far entailed more and more law and legal repression rather than its abolition. Despite these discouraging experiences, there still remain distinguished exponents of the view that man, at the primitive level, is innately good, and that it is the social and political organization of civilized life which has introduced the seeds of violence and disorder, and which, in their turn, have led to systems of legal coercion. One of the main theses of Elliot Smith, in his book On Human History, first published in 1930, is the innate goodness and peacefulness of mankind. Kind of an ironic time to come to that conclusion, but anyway. Smith states in his book, the evidence is so definite and abundant that it becomes a problem of psychological interest to discuss why men persist in denying the fact of man's innate peacefulness. Each of us knows from his own experience that his fellows are, on the whole, kindly and well-intentioned. I'm not sure where Mr. Smith was experiencing these things, but anyway, I'll go on. More of the friction and discord of our lives are obviously the result of such exasperations and conflicts as civilization itself creates. Envy, malice, and all uncharitableness usually have for the object of their expression some artificial aim, from the pursuit of which primitive man is exempt. Few will deny that numerous ills from which we suffer are the direct result of the stresses, tensions, and conflicts characteristic of a civilized and therefore complex mode of existence. All the same, Elliot Smith's contrast between natural and civilized man seems one-sided and oversimplified. Readers of Mary Shelley's Frankenstein will recall how Frankenstein creates a monster in human form, which, though possessed of human feelings, eventually turns upon and slays its creator. The romance seems symbolic of the duality of human nature. Man may well possess innate tendencies towards what we call goodness, namely those relationships which arise out of sympathy and cooperation, for without these all social life, the distinctive character of man, would be impossible. But there is also a dynamic side to human nature which may be directed to either creative or destructive ends. The well-meaning philosophic anarchist, even when he is most concerned to give scope to man's creative impulses, is apt to gloss over or ignore the darker side of the nature of man. Sir Herbert Reed, for instance, argues that human groups have always spontaneously associated themselves into groups for mutual aid and to satisfy their needs, and so can be relied upon voluntarily to organize a social economy which will ensure the satisfaction of their needs. The anarchist, he tells us, conceives society as a balance or harmony of groups. The only difficulty is their harmonious interrelation. But is not the promotion of such harmony a function which must be conferred on some state organization? Sir Herbert Reed's answer is twofold. In the first place, he believes that this function would largely disappear with the elimination of economic motivation from society. Crime, for example, is largely a reaction to the institution of private property. Now, that's definitely a live issue. Reed continues. Matters such as infant education and public morality are matters of common sense to be solved by reference to the innate goodwill of the community. With universal decentralization of authority and the simplification of life, including the disappearance of inhuman entities like the modern city, any disputes can be resolved on a local basis. If I can interject here, what's interesting is this the desire of decoupling from cities, decoupling from laws, certainly looks very different in 2022 when you consider some of the political forces that are at work today. Anyway, I'll continue. Reed goes on. Local associations may form their courts, and their courts are sufficient to administer a common law based on common sense. Lloyd concludes the chapter as follows. It will be noted that Reed differs from some anarchists in recognizing the need for some kind of general law, and insists only on rejecting all the coercive apparatus of centralized control. Anarchism, he explains, means literally a society without an archos, that is to say, without a ruler. It does not mean a society without law, and therefore it does not mean a society without order. The anarchist accepts the social contract, but he interprets that contract in a particular way, which he believes to be the way most justified by reason. The recognition that even in the simplest form of society, some system of rules is necessary, seems almost inevitable. In any society, whether primitive or complex, it will be necessary to have rules which lay down the conditions under which men and women may mate and live together. Well, obviously they didn't conceive of all the eventual possibilities there in 1964. But anyway, I will continue. Rules governing family relationships, conditions under which economic and food gathering or hunting activities are to be organized, and the exclusion of acts which are regarded as inimical to the welfare of the family, or of larger groups such as the tribe or the whole community. Moreover, in a complex civilized community, even if simplified to the degree dear to the heart of an anarchist like Reed, there will still have to be a large apparatus of rules governing family, social, and economic life. The idea that human society on whatever level could ever conceivably exist on the basis that each man should simply do whatever he thinks right in the particular circumstances is too fanciful to deserve serious consideration. Such a society would not be merely, as Reed puts it, a society without order, but the very negation of society itself.